Hello, everyone, and welcome to Uncivil Law. And my friends, things are not going super duper well for Rudy Giuliani. Rudy Giuliani used to be one hell of a lawyer. He used to be America's mayor. He cleaned up Times Square. He basically created RICO as we know it and got it to kill the mob and all kinds of stuff. But he's having problems in his later life. Things are not going well for him. And one of the things that's not going very well for him is things that he can't find good lawyers, apparently, to represent him, because he's got some problems right now in federal court, including a motion for sanctions and contempt. And his lawyer's motion, or his lawyer's response, leaves a little bit to be desired. So things are apparently finding top quality legal talent is a bit of an issue. So we bring ourselves to the case of Ruby Freeman and Wandrea Moss versus Rudy Giuliani for the purposes of today's discussion in the opposition to plaintiff's motion to hold defendant, that is Rudy Giuliani, in contempt and impose sanctions. Rudy Giuliani would prefer very much if you don't hold him in contempt and impose sanctions, but his explanation as to why he would prefer that leaves something to be desired. This is written by Joseph Karmata, who, could learn how to write better. Okay, first of all, we've got the table of contents. And the table of contents leave a little bit to be desired. The preliminary statement and then argument, which doesn't have a page number, I guess, or unless the preliminary statement is itself 18 pages, which is one hell of a length of a preliminary statement. That is a lot of preliminary statement, man. Do you want to break that up? Could I interest you in a subsection? And then the argument is standard of review and then holdings and then just conclusion 4 page later. I don't know, man. I don't know. Could I interest you in some subparts or some sub-numbering or something? Or maybe reframing some of this? The table of contents is not inspiring me. But let's see how it goes. Table of authorities looks pretty good, though. I mean, it's fine. All right, let's see what we got. Defendant Rudy Giuliani respectfully submits this memorandum of law in opposition to plaintiff's motion pursuant to federal rules and the court's inherent authority for an order holding the defendant in civil contempt and imposing sanctions. Plaintiff seeks to hold defendant in contempt of court's orders of October the 28th and to sanction defendant accordingly, including pursuant to the federal rules. Plaintiff memorandum of law states that Mr. Giuliani has not provided a single document in response to plaintiff's discovery orders in this matter, notwithstanding multiple orders from the court requiring to do so. That is not true and false. One or the other would have been fine. I don't know that we need to say not true and false. Okay, that's, you know, the undeniable fact is that defendant's prior counsel, Kenneth Caruso and David Lofkowitz, were counsel to defendant until November 26, when this court permitted them to withdraw. Noted. Defendant obtained new counsel, Joseph Camatre, replacing Kenneth Caruso and David Lofkowitz on November the 26th. Defendant's present counsel quickly began to review all the court's orders and began to obtain all responses to the plaintiff's discovery demands to comply with all this court's orders and plaintiff's discovery demands. Okay. As this court should know, plaintiff obtained probably one of the largest judgments for defamation ever granted to plaintiff in the United States. The $145,969,000 plus interest. That is a lot of defamation, I will agree. Notwithstanding the fact that the judgment is on appeal before the United States Court of Appeals for the D.C. Circuit, defendant counsel presently immediately began the process of causing the turnover of assets to the defendant who were appointed by the receivers. Well, yeah, that's how that would work, right? Unless the judgment has been stayed pending the appeal, you can go execute on the judgment once the judgment is entered. So they're appealing the judgment. Okay, well, unless the judgment is stayed, then it's a valid judgment, which means you can go start collecting against it. And if the Court of Appeals reverses, then you'd have to give the money back or whatever. But yeah, They've started to collect on the judgment of the trial court. Right. As one does. That's one of the things that you kind of normally do. Right. Once you receive the order for the money, you go get the money. That's kind of, yeah. All right. In this court's order of October the 22nd, the court stated that federal rules of civil procedure permits him to post a superseding bond in the district of court to stay the enforcement of the disposition. Huzzah! Huzzah! So there is some sort of mechanism to stay. So, okay, great. All right. A party against whom a monetary judgment has been entered may obtain a stay of judgment pending appeal by posting a bond. Fantastic. Describing the bond requirement as intended to ensure the prevailing party will recover in full if the decision should be affirmed, while protecting the other side against the risk that payment cannot be recouped if the decision should be reversed. The fact is, the bond would have had to be an amount in excess of $145 million, and the bankruptcy petition filed by defendant, his assets totaled between $1 million and $10 million. There's no possible way for him to have obtained any bond due to the value of the judgment, which is on appeal. It's anticipated will be reversed, or the judgment amount will be gracefully reduced. Okay, so there's a mechanism by which you have to post the bond. How much is the bond? Well, the bond is apparently $145 million. That's a lot of bond. I would tend to agree that is a lot of bond, but that apparently is the amount. And he doesn't have $145 million, so he can't post it. Okay, so it's a valid judgment then, and we can start collecting against it? Great. What are we talking about? Are we just whining? Are we whining, or do we have legal points in here somewhere? Anywhere you want to drop a legal point, you let me know. Every human being has political beliefs. And no matter what the court's personal beliefs are, the court should recognize that you have a defendant here with an enormous judgment against him, as the plaintiffs were awarded a judgment now in excess of $145,969,000, which includes $75 million in punitive damages. Okay. And this court should recognize that plaintiffs' counsel are politically and apparently are swayed towards the Democratic Party. What? And you have a defendant who is a Republican mayor and who is an attorney for the former and future president, Donald Trump, who was and deeply rooted in Republican beliefs. What? There is no way that this court cannot view this as a political case, because that's exactly what it is, or there never been an astronomical judgment against the defendant. Wow. No. Look, this is not how you write this. This is not even close to how you write this. It's like, did you know that Rudy Giuliani is a Republican? And the people that are suing him are Democrats? Did you know that, Your Honor? And this amount is a really, really big number. Did you know that, Your Honor? I don't think the court's going to be super impressed, man. This court should know that one or more plaintiffs' counsel were partners with Hunter Biden. Who cares? As Boy Schleiss Flexner, President Joe Biden's son, and involved with, upon information belief, Burisma Holdings and or Ukrainian issues. What the actual fuck? Who cares? Who cares who the plaintiff's lawyers are? And they also represented Joe Biden's son. All right. And they might have had some ties there too, in so much as Hunter Biden has things to do with Ukraine, then his lawyers might have been advising him relating to Ukraine. I mean, probably that's a reasonably safe bet. His lawyers probably were providing him advice that had some sort of connection to Ukraine, and therefore, what exactly now? I don't know. these issues became very, very political. Oh, very, very political. Is that what they are? They're not just political. They're not just very political. They're very, very political. What the hell? And charged during the 2020 presidential campaign and thereafter, one or more organizations of the plaintiff counsel are politically based organizations, such as the organization Uniting to Protect Democracy, whose website says protecting democracy is a group dedicated to defeating the authoritarian threat and producing liberal democracy. I'd like to take note that absolutely none of this in any way challenges the defamation itself. Like, it just challenges their motivation as opposed to like their legal claim, which is not even close to how courts work, right? If you have a legal claim, your motive in enforcing your claim is pretty much irrelevant, except in some very unusual circumstances. Like, how is motive reasonable? Unless you're the government, I guess. If you're the government, then your motive might be relevant, because then we're talking about maybe selective prosecution, or maybe we're talking about some sort of deprivation of civil rights or something like that, right? So if you're the government, then yeah, maybe your motivation matters. If you're a private party and you're like, this is my rights, I'd like it now, and you're like, why? What are we talking about? It's just like, I have the legal right. Motive is, what are we talking about? And none of this is relating to defamation, or even like the amount being excessive as a matter of law, which you could try that argument too. We saw that, for example, in the Maya Kowalski case, right? We saw that with J Hatch's appeal, where they're saying, for example, in their appellate documents, that they think that this amount is wildly in excess of the comparables. And then they brought out some cases they think are comparable. And they're like, okay, here are other cases we think are comparable, and this award is way, way in excess of any of that. Therefore, this award is therefore legally problematic in some way. This is just, it's legally problematic because they're affiliated with the Democratic Party. No matter what anyone says, the truth and fact is that plaintiffs are represented by those who believe in liberal democracy, and you have a defendant whose beliefs are the antithesis of plaintiffs' counsel. There has got to be a better way to write that, man. That is like the worst possible way to write that. Plaintiffs are represented by those who believe in liberal democracy, and the defendant beliefs are the antithesis of that. So illiberal, not democracy, by the way you wrote that. That is the worst possible way of writing that. My opposition believes in liberal democracy, and I'm the antithesis of that. Wow. Wow. Plaintiffs, through their counsel, filed judgment in the United States District Court for the Southern District of Florida on August 5th of 2024 and filed their judgment in the United States District Court for the Southern District of New York on the same day. Fine. On August the 5th of 2024, there was no way for plaintiff and their counsel did not know defendant was a citizen of, domiciled in, and a permanent resident of the state of New York or Florida, who was and is actually residing in his Florida condominium, where he is entitled to homestead protection under the Florida Constitution. Well, be that as it may, those would still be the places to file the judgment. And then you would say, like, you can't get this money because of this rule, right? That's just a counter. Like, so whether or not they know he's entitled to homestead or not, like, that's still the appropriate place to file the judgment, because that's where the assets are. So that's where you go file the judgment. And then the other side says you can't get the money because homestead. And the other side says, yes, I can because of whatever. And then, you know, you fight about it legally as one does. If this was not a political case, the plaintiffs would have filed for determination of Homestead in the Circuit Court of Palm Beach County, Florida. But they did not do so because they want a New York court to help plaintiffs achieve their goals. Well, no, they have a judgment from the New York court already, and they're filing the judgment in Florida as part of perfecting the judgment or executing the judgment. I suppose they could have filed in the Circuit Court of Palm Beach County, but they chose to file in the Southern District of Florida. Were they not allowed to do that? Is that the wrong place to file? Is it a jurisdiction problem? Should you be telling the Southern District of Florida about why they can't file there? This is the wrong place to file? And why are you telling the Court of New York about it? Tell the Court of Florida about it. This is the wrong... What are you talking about? Okay. One would ask, why would plaintiff file their judgment in Florida and New York? Well, the judgment was from New York, so filing it in New York makes logical sense. And then apparently the assets are in Florida, so I filed it in Florida. I mean, seems like a pretty reasonable thing to do. And then not proceeding enforcing the judgment in Florida or the United States District Court for the Southern District of Florida, but also seek to enforce judgment in New York and try to have a federal court in New York interpret Florida constitutional law and Florida Supreme Court case law. Well, I mean, not to put too fine a point on it, but that kind of thing happens not unfrequently. It is not like completely unheard of. I mean, the judgment is in New York, and they'd like to get their judgment in New York. And there's some protections under Florida law to which the New York court might have to give in its interpretation. But like, that's not unheard of. Courts of one jurisdiction applying another jurisdiction's laws. It happens. It happens in contract cases. It happens in judgments. It happens in a lot of different kind of cases. So it's like, yeah, a court in New York could try to apply things in Florida, and maybe that's the appropriate place to get it. And even if it's not, you're not telling the New York court why it's not. You're just whining about it. You're not saying, New York court, you can't do this because of this rule, or this rule. You're just whining. Try whining less. The answer appears to be forum shopping, because plaintiffs likely believe a Florida court would undoubtedly grant Homestead protection to defendant, because Homestead is properly assumed to be valid once claimed, while the plaintiffs' counsel likely believes they'll have a better chance of having a federal court in New York trying to interpret Florida's constitutional law in plaintiffs' favor. Well, not to put too fine a point on it, but if they're trying to apply Florida's law, the New York court would be bound by Florida's law, the same as the Florida court. So you can say, okay, well, here's this decision from Florida, New York court, and you're required to apply that because we're trying to apply Florida law. I'm like, okay. I mean, I understand that. It's not unknown to courts. It's not the first time we've ever tried to do this before. There would be no chance of taking defendant's Florida condominium, which is a homestead in Florida, which Florida courts have routinely resolved and decided on homestead and Florida constitutional law. Great, then you should have no problem in New York. It is believed this case will be the first case, the United States District Court for the Southern District of New York, where a court is deciding Florida homestead and Florida constitutional law. There is no way that that can possibly be true. There is no way that that can be true. With the amount of people who travel between New York and Florida, there is no way that this is the first time this has ever happened. This is a case of first impression. Oh, is it? Because it's believed that any other cases ever involving an interpretation of Florida Constitution provisions regarding homestead have been decided in the courts of the state of Florida and not New York. Well, all the binding law would be in Florida. That's true. All the binding law would be in Florida. This case does not belong to this case in Florida, in this court, but this is where it's being litigated, as this court has not yet granted dismissal of this case or transferred venue to the United States District Court for the Southern District of Florida. Okay. More whining noises. Plaintiffs and their counsel are seeking to take every asset of the defendant. Well, yeah, that's up to the amount they're owed. Yeah. And you say he doesn't have that amount of money. So yes, they're trying to take everything he has, correct? Before there's a change in administration from President Biden and President Trump, it's going to have no impact. The fact is, this case evolved from the 2020 election, where the defendant worked for President Trump, and while plaintiff's counsel was believed to have supported President Biden, this is what the fierce protection of this case derives from. New York Renal MD for $5 said, sad about this. New Yorkers owe Giuliani a debt of gratitude for cleaning up New York. I tend to agree. I hope some legally competent steps him up for his legacy. I mean, Giuliani was the man. Giuliani was the man. And seeing how far he's fallen is a very sad thing. I mean, he cleaned up New York. Times Square used to be a dirty, filthy, red light district, and not a good kind. It was crime ridden. It was trashy and diseased. And Rudy Giuliani cleaned up Times Square, and it is completely unrecognizable today compared to what it was. And then, and before that, he basically ended the mafia in New York. Personally. He was the one who took RICO and really figured out how to use it. He was the one who really figured out how to use RICO and basically ended the mafia. So, those are some pretty great accomplishments in one person's career. And then it's like, dude, what happened to you, man? What happened? You used to be the best. You used to be the greatest. The fact is, this case evolved from the 2020 election where defendant worked for President Trump, and while plaintiff's counsel was believed to have supported President Biden. This is the fierce prosecution of this case derives from. What the hell? Defendant was very outspoken against Hunter Biden and the Hunter Biden laptop. How are we talking about this at this point? In which many people said was Russian disinformation, when the truth eventually came out that Hunter Biden's laptop was authentic and real. But why are we talking about this now? At least one of the plaintiff's counsels has emails in the public domain with Hunter Biden on the same emails. And such counsel was special assistant to President Barack Obama and associate White House counsel. No one cares. The fact is that this case is not really about the judgment that the plaintiffs obtained in a ghastly sum, among the largest judgment ever against an individual for defamation in the United States. This is a battle between the left and the right, and this is one of the last battles that exist from the 2020 election. Blech. Blech. This is so poorly written. This is so incredibly poorly written. It's just whining and spurging all over the page, man. There's not really any legal authority. It's just I'm mad, and this was political, and this is a sham, and this is just old men yells at cloud. This is sad. This is sad. It's like, it just makes me want to rule against you. It's like, I don't even know what the issue is, and I want to rule against you. This is just so poorly written. This is sad. On the internet and upon information belief, the Wilkie, Farr, and Gallagher website, what the fuck are we doing? It states or stated with a posted dating August the 30th, 2023, that a Wilkie pro bono team led by partners Michael Gottlieb and Meryl Gavinsky along with co-counsel at Protect Democracy. And are we just trying to prove they're Democrats? I mean, probably. Why am I reading this? I don't know, but I guess I'm going to keep reading it anyway. Won a landmark victory today against Rudy Giuliani in a federal defamation suit in U.S. District Court for the District of Columbia on behalf of Fulton County, Georgia election workers. In an August 30th opinion, Judge Howe granted Wilkie's motions for sanctions for Mr. Giuliani's willful discovery misconduct and ordered the most drastic sanction, default judgment. That's pretty drastic. Defamation, intentional infliction of emotional distress, civil conspiracy stemming from statements he made about Miss Freeman and Miss Moss to intentionally undermine the results of the 2020 presidential election. Wilkie, along with co-counsel, filed this lawsuit in December 2021 and has devoted thousands of hours to litigating the matter, including filing more than 20 discovery-related motions. Okay. The order leaves outstanding only the amount of damages Mr. Giuliani owes, including in the form of punitive damages, which will be determined at a trial in the coming months. Today's decision comes after nearly 2 years of litigation. The ruling is a significant victory and affirms what Wilkie's team, co-counsel, and their clients have always known to be true, that Miss Moss and Miss Freeman honorably performed their civic duty in the 2020 presidential election in full compliance with law, and the allegations of election fraud made against them have been false since day one. Yeah. Partner Michael Gottlieb was interviewed on CNN, MSNBC, and NPR, and partner Meryl Gavinsky appeared on News Nation and MSNBC, respectively, to discuss the victory. This was an important win also covered by other global media organizations, including the Wall Street Journal, the New York Times, Washington Post, Reuters, Politico, Associated Press, and more. Miss Moss and Miss Freeman are represented by pro bono Wilkie team that includes partners Michael Gottlieb and Meryl Gavinsky and associate M. Ann Houghton Larson, J. Tyler Notlib, Tim Ryan, Logan Kenny, Maggie McCurdy, and Perry Haser. Co-counsel on the case is Protect Democracy, Van DuBois of DuBois Miller. No one fucking cares. Why are you quoting me their website? No one cares. Okay. So this is a law firm whose members are presumably Democrats and at least have taken on Democratic causes and represented Democratic interests for the Democratic Party. I mean, okay. I mean, so fucking what? Does this have anything to do with the judge's order? Does this have anything to do with whether or not the default judgment is warranted? Does it have anything to do with the amount? Does it have anything to do with whether or not this is the right court to hear this issue? Who cares what their law firm does? Who cares? Their law firm wrote something on their website about how they were proud of winning. Exciting. No one cares. Note that Wilkie, Farr, and Gallagher made this allegedly pro bono project, likely to try to destroy defendant, while increasing the publicity and promotion for Wilkie, Farr, and Gallagher as very aggressive and tenuous attorneys. That is the stupidest thing I've ever read in my life. That is the stupidest thing I have ever read in my life. Okay, guys, did you know that the law firm was motivated by self-interest? Whoa. And they said that they were doing it pro bono, so that means they weren't doing it for the money. Okay, so if they weren't doing it for the money, why might else they be doing it? For the PR? Did you know that they're trying to make themselves look like really good and shit? Did you know that they're trying to make themselves look really good and really competent and like they're really, really good attorneys and they're aggressive and they're tenacious and they're really, really, really willing to work for their clients, even if they're not being paid? That's just how good they are. They kick ass and take names just for the fun of it. Did you know that they were trying to make themselves look good? Did you know that? What the hell? Note also that judgment is the subject to this action was not judgment on the merits, but based on default because Judge Howe granted the motion, resulting in a default judgment of all claims: defamation, intentional infliction, civil conspiracy. This case was not decided on what actually occurred. This judge does not fucking care. This judge does not fucking care. Okay? This apparently resulted from a decision in DC. Okay? We have a judgment in DC, and it's a valid judgment. And I've now taken it to a court of a different jurisdiction and said, hey, I have a valid judgment. And now you're trying to tell this court, hey, did you know that judgment was bad? Why? Because that judge ruled default. Okay, were they not allowed to do that? No. Oh, all right, well, tell it to the Court of Appeals. Why are you telling me? I have here a valid judgment issued by a court. I'm going to go execute on that now because it's valid. Did you know that it wasn't decided on the merits? I didn't know that. Thank you for bringing it to the court's attention. Also, I think it's raining outside right now. Okay. On the internet and or their website, I'd ask what the difference is. I mean, I know what the answer is to that question, but I'm not sure they do. Unless we're going like 20, even more than 20 years ago. We'd have to be going like 30 years ago for that distinction to matter. So 30 years ago, maybe we would be out, but I'm not sure today. Okay, never mind. Pressing on. I'm not going to think about it too much. On the internet and or their website, Wilkie, Farr, and Gallagher stated that they devoted thousands of hours to litigating the matter, including filing more than 20 discovery-related motions. Okay, that's how the plaintiffs won, by bombarding defendant with discovery, hoping that we get the judge to buy their story of discovery disobedience. Wow, it must be the first time ever that a lawyer has tried to like swamp the other side in discovery or discovery motions. That must be the first time that's ever happened. That's what plaintiff counsel was doing in this court. Plaintiffs also say they are represented by the Wilkie team that includes the partners Michael Gottlieb, Merrill Gavinsky, and associate M. Ann Helton Larson, Tyler Notlib, Tim Ryan, Logan Kenny, Michael McCurdy, and Perry Hasser. Jefferson Steve Post for $2 says, I prefer to keep my websites off the internet. Fair enough. Co-counsel on this case is Protect Democracy and Vaughn DuBois of DuBois Miller. There actually have been more than 9 attorneys working, propounding the defendants with discovery demands in this case, as they had in the DC case, because plaintiff's motive is to try to overwhelm defendant and his counsel and win on default and sanctions, because they cannot and could not prevail on merits. Well, first of all, assuming all that's true, first of all, one, welcome to litigation. 2, if that is a problem, either 1, tell the trial court about it, or 2, tell the DC Court of Appeals about it. Right? If that's the problem, if you feel like there's been some sort of malfeasance, then tell the trial court, tell the Court of Appeals about it. Why are you telling some court in New York about it? Okay. The following is posted on the internet and their website. Are we going to do more of their website stuff? Oh my God, why? A Wilkie pro bono team has been recognized by the AmLaw Litigation Daily with a shout out for its success in securing the dismissal of Rudy Giuliani's bankruptcy case. On Friday, July 12th, U.S. bankruptcy judge Sean Lane dismissed Giuliani's bankruptcy protection case, clearing the way for Wilkie's clients, Shane Moss and Ruby Freeman, to start collecting the amount that's owed to them. Last December, in a landmark suit, Wilkie secured the $148.1 million in damages for Shane and Ruby for the harm Rudy Giuliani caused by spreading lies that they had intentionally undermined the results of the 2020 presidential election in Georgia. Partner and chair of the Business Reorganization and Restructuring Department, Rachel Strickland, counsel Aaron Nathan, and associate James Burbidge played a key role in securing the bankruptcy case dismissal. The Wilkie team also included partners Michael Gottlieb, Meryl Govinsky, and Kristen Bender, associate M. Ann Halton Larson, J. Tyler Notlib, Maggie McCurdy, Perry Haser, Jesse Grabber, and Maureen Lawson. Co-counsel include Vaughn DuBois of DuBois Miller and John Lafford of Protect Democracy. Learn more about the case here. It is believed that a significant factor in this case is for pro bono attorneys to get promotion and free advertisement in the press, promoting Wilkie, Farr, and Gallagher. No shit. No shit. Why would they do this? If not the money. Why would they file like 20 discovery motions and be filing in DC and filing in New York and filing in Florida? If they're not doing it for the money, why else are they doing it? Might they be doing it for the PR? Might they be doing it to promote themselves and their firm? Might they be doing themselves to show themselves as we're the ones who brought down Rudy Giuliani? Might they be doing it to promote themselves and their law practice? No. No. You fucking idiot. Are you telling us like this, like we're supposed to be shocked by it? Are we supposed to be shocked and appalled? Lawyers motivated by self-interest. Let me tell you more about it. Note how many attorneys are working as set forth in the posting. No one fucking cares. The following is posted on the internet and or their website. We're still not sure about what the difference is over there, though. About Wilkie, Farr, and Gallagher. Rachel Strickland, partner and chair of Wilkie Business Reorganization and Restructuring, appeared on CNN last week to discuss the recent dismissal of Rudy Giuliani's bankruptcy case and what it meant for Wilkie clients Shane Moss and Ruby Freeman. On January 12th, the U.S. bankruptcy judge, Sean Lane dismissed Giuliani's bankruptcy protection case, clearing the way for Shane and Ruby to start collecting the money that is owed them. In an interview with Caitlin Collins on CNN's The Source, Rachel discussed the details of the court proceeding and the Wilkie team's instructions to immediately pursue the assets on behalf of Shane and Ruby. Yeah. Right. Correct. So let me make sure I understand this correctly. All right, Shane and Ruby believe that they have a cause of action. They found lawyers. Their lawyers represented them. Their lawyers pursued their case diligently. Some might even say zealously in a court of law, including by filing legal proceedings such as discovery. They then were unhappy. They then went to the trial court and said, we think that they're jerking us around. And the trial court said, yeah, you're right. They're jerking you around. How about default judgment? And then they said, we'd like some money, please. And someone said, how about like $140 million? And then they're like, cool. Can we have the money now? Can I have the money? Money go here? Money go here? I'd like the money now, please. And therefore And therefore, what? And then Giuliani said, I don't want to pay because I'm bankrupt. And then I went to the bankruptcy court and I'm like, I think they're jerking you around, bankruptcy court. And the bankruptcy court's like, yeah, you're right. They're jerking you around. Bankruptcy petitions dismissed. I was like, cool. Can I have money now? Money go here. Money go here. Money go here in the money spot. This is where the money goes. I can have money now. Also, I'm just the greatest. I'm an awesome lawyer. I'm just the bestest lawyer. And I'd like to tell CNN, the Washington Post, the New York Times, Reuters, and anyone else who will listen about just how great I am. Did you know how great I am? Did you know I'm the best? Did you know I got all this judgment from my client, me and my team of lawyers? There's like 11 of us. Did you know that we do this? Do you know that this is how hard we work for our clients? Do you know this is how hard we work? They're trying to jerk us around every step of the way, but we're not going to let them get away with it. We're not going to let them get away with it until money go in palm. We want money now. Do you know how great we are as lawyers? What the hell do you think we're doing over here, man? What are you talking about? This is like normal. Last December, in a landmark defamation suit, the Wilkie pro bono team secured $148.1 million in damages for the harm Rudy Giuliani caused spreading the lies. They intentionally undermined the results. By the way, just for the record, I want to make clear, because I kind of alluded to this earlier before, I'm not for the record like necessarily saying that the judge was correct in the default. I don't know. I haven't looked into it. I'm not correct. I'm not necessarily saying that the amount is in excess of anything that's reasonable. I don't know. I haven't looked into it. I'm not saying that the amount is in excess of like any sort of comparables. I don't know. I haven't looked into it. So I'm not necessarily saying that there aren't reasons to disagree with the judgment in how it sort of came to be. Like you could, and that's one of the reasons we have courts of appeal. You can tell the courts of appeal all about it, right? You know, it's not fair. They were acting in bad faith, Your Honor. This amount is too much. It's in excess of this, and it's not fair because of this reason, this reason, this reason, this reason. It's like there are a lot of reasons to tell the DC court or the DC Court of Appeals about it. Maybe this judgment is flawed in some way. Maybe it's too much. Maybe the trial court shouldn't have issued the default. Maybe a lot of things. I don't know. I just don't know that, one, why you're telling the Court of New York about it, and two, why you're doing it in such a whiny, bitchy way. This is so whiny and so bitchy. It's just like, isn't it fair? I'm like, dude, man, do you have a legal argument? My kingdom for a legal argument. My kingdom for a citation to a case. Any case at all. Could I see a citation to a case instead of just bitching about it? Please, give me some law. Again, this case is to promote the interests of the law firm, no shit. And the court should be fair to defendant by knowing the plaintiff's goals here are to win by default, or like, well, literally any way would be nice, but default certainly is a way. I'll take that. Or sanction, and not on the merits, because they'll lose on the merits. Well, if they'll lose on the merits, then it sounds like you really fucked around by fucking around with discovery. And, you know, most courts are pretty loath to give default. So you probably fucked around pretty hard to find default. Not saying that it's not attackable, not saying the trial court went too far. Maybe they did. I just don't know why you're telling the Court of New York about it. The following is posted on the National Security Institute website titled Michael Gottlieb in the News. Okay. Giuliani agrees to cease election fraud, mentioning NSI visiting fellow Michael Gottlieb. Litigation of the week, holding Giuliani accountable for defaming Georgia election workers. Quoting Gottlieb. Rudy Giuliani files for bankruptcy amid legal battles and $148 million defamation verdict. Quoting Michael Gottlieb. Are you just trying to make Michael Gottlieb look like awesome? Michael's the best. Michael's the greatest. And he's living in your head rent free, isn't he, man? Damn. He's the greatest. You're such a fucking idiot, whoever wrote this. I can't believe it. Rudy, and why are some of them underlined and some of them not, by the way? Why are some of these underlined and some of them are not? Pick one. Pick one. I don't know what the blue book says. I can't be bothered to look it up right now, but just pick one. Pick a consistent style. Pick a style. Why are some of them underlined and some of them not? Rudy Giuliani files for bankruptcy after being ordered to pay $148 million in defamation case. This one's underlined, though. It must mean it's special. Quoting Gottlieb. Rudy Giuliani facing $146 million in bankruptcy in New York. Quoting Gottlieb. Election workers who won $148 million in damages from Rudy Giuliani's sue again to stop lies. Quoting Gottlieb. Man, it certainly seems like this Michael Gottlieb guy certainly knows how to call a press reporter or two. He'd really like the press to know about how awesome he is as a lawyer. He'd really like the press to know just how great he is, and he seems to be doing a pretty good job in contacting people and getting them to write about how awesome of a lawyer he is. He kind of understood the assignment, man. Woof. Why Ruby Freeman and Shane Moss are suing Rudy Giuliani again? Quoting Gottlieb. Georgia election workers sue Rudy Giuliani for defamation again after winning $148 million. Quoting Gottlieb. They just won $148 million against Gottlieb. Now they're suing him again. Quoting Gottlieb. Giuliani can't axe Georgia poll workers defamation claim. Again, this one mysteriously underlined for some reason. Unclear why. Unclear why. Maybe it's like evil or something. Maybe it's let's come up with answers in chat why some of the case names are underlined or some of the news article names are underlined. Why are some of the news article underlined and why are some not underlined? Wrong answers only. Wrong answers only. Why are the correct answer is because this guy's an idiot and doesn't know how to do a consistent style. That is the correct answer. So what is the wrong answer? Well, wrong answers only. Why are some of the news articles underlined and some not? I will now take your suggestions. Judge denies Rudy Giuliani's motion to dismiss defamation lawsuit from Georgia election workers. Wilkie Farr nabs former White House lawyer to lead crisis management practice. Well, that might be a good person to lead a crisis management practice. A White House lawyer might have some experience in crisis management, so that might be a good person to do that. White House alum leaves boys to launch Wilkie Crisis Response Group. Quoting Michael Gottlieb. Michael Gottlieb is just the best lawyer ever. That's what we've learned. The court should see. The court should see. Now we're just doing wish casting. That's what we're doing. Wish casting. Wish casting in a legal document. I don't know, man. The court should see that Wilkie Farr and Gallagher, allegedly working pro bono, in quotes. Okay. Is publicizing this case and all cases involving defendant Rudy Giuliani, which likely will or has generated probably millions of dollars from Wilkie Farr to Gallagher from other clients who dislike defendant Rudy Giuliani and or President Trump. Oh my God, he figured it out. Oh my God, he figured it out. Well, even a blind squirrel can find an acorn every once in a while, man. He figured it out. They say this is pro bono, but in actuality, he's probably gotten millions of dollars from other clients who really dislike Giuliani and or President Trump and are like, oh, these lawyers are the kind of lawyers I want. Let me go hire them and got money. So it wasn't really pro bono. He did it for the notoriety and he did it for the publicity. And he's been rewarded by millions of dollars from other people based on the publicity and notoriety. Yeah, you just figured it out, didn't you? You figured out the grand conspiracy. Round of applause. Round of applause for piecing it together. You are just so incredibly smart. No shit, Sherlock. That's what was happening. No shit. Unbelievable. You're the best. Pro bono attorneys would not spend thousands of hours on a pro bono assignment without an ulterior motive, a profit motive. Whoa, so you're saying that it wasn't just true altruism? They did it for reasons other than necessarily money from these clients. There were other motivations, including potentially even monetary motivations from other clients who would see it and then give them money? Whoa, you figured it out. Did you figure it all out by yourself? Did you figure it all out? You're such a big boy. Wow, did you figure it all out by yourself? You're a big boy, man. You get the gold star at kindergarten. You're amazing. This court has fact-tracked this case, and it's perplexing why this rapid rocket docket approach has been utilized. But the fact is that plaintiffs want this case over by January 20, 2025. Well, presumably they want it over as soon as possible because it's been going on for a little while. Plus it's pro bono. And, it is time that they could be spending doing other things. So, they probably like it over sooner rather than later. That'd be good for them. Because it's not in Wilkie, Forrest, and Gallagher's best interest to have this case proceeding once there's a new administration in Washington, as the clients of Wilkie, Farr, and Gallagher, who would have to work with the new administration in Washington, may be offended by the approaches taken by Wilkie, Farr, and Gallagher with their manner of overly aggressive discovery tactics designed to win. Okay, let me make sure I understand this correctly. Where's my highlighter? Hold on. Okay. As clients of Wilkie, Farr, and Gallagher may be offended by the approach. Okay, hold on. May be offended by the approaches taken by Wilkie, Farr, and Gallagher that were designed to win. So your theory is that potential clients of the law firm will be offended that the law firm took tactics designed to win. That is your theory. The potential clients of the law firm will be offended that the law firm tried to win. Okay. All right. All right. Fine. Sure. The court should try to avoid politics arrived in this case. While the honorable judge of this court was nominated for the current district judge position, no Democratic senators voted against the nominee of the honor judge, but 29 Republican senators voted against the honorable judge. Really? Hopefully, the honor judge will be able to be unbiased against defendant. Holy shit, dude. Holy shit, dude. Did you just really do that? Did you know your honor was supported by the Democrats? 29 Republicans voted against you. Hopefully you won't hold it against us. Holy shit, dude. Come on. Really? Wow. However, even subconsciously, a human being can have political bias, and the rapid rocket docket approach by this court and entertaining so many of plaintiffs' motions and letters from plaintiffs' counsel and ruling against the defendant nearly 100% of the time is troubling. Well, I'll tell you what, I'm beginning to understand. I'm a Republican. And I'm beginning to understand why the court is ruling against the defendants 100% of the time. And I'm not sensing bias, right? We've had this discussion many times. Just because you're ruling for one side or the other doesn't necessarily mean you're biased. Maybe they just suck that hard. I'm Republican, and I'm beginning to understand why this Democrat judge is ruling against the Republican apparently 100% of the time. I'm thinking maybe it's not bias. I'm thinking maybe it's just that bad. Yeah, these motions are not law, they're posturing. It's not even good posturing, it's bad posturing. It's whiny. It's being bitchy and whiny. When was the last time we saw a citation in this to a law? The last time we saw a citation to a law was, I think, in the introductory paragraph 15 pages ago, when they mentioned that this was being done under a rule like 70 whatever it is of the federal rules and also inherent authority. I think it was the last time we saw a citation to a law. I have not seen a case citation anywhere, man. I'll tell you what, man. It's believed that plaintiff counsel's goal is to bombard defendant with tons of discovery using dozens of attorneys, make it nearly impossible for defendants to timely respond. Well, you could have asked for an extension based on that. I mean, you could have asked for a lot of things. And then following motions after motion against defendant in the hope that one of the motions for sanctions will stick. The plaintiff's playbook here is the same as it was in the United States District Court for the District of Columbia. That's how plaintiffs won their judgment in the United States District Court for the District of Columbia. Sanctions, not on the merits. Imagine this is good. This is whiny. This is maximum wine right here. Imagine obtaining $145 million judgment based on sanctions only. What kind of a sentence is that? This is what happened. It's on appeal and likely to be reversed. Without reading one word of the district court's findings in DC. No, I don't think it's likely to be reversed. No. Like, even if it should be reversed. No. No. There are really no other cases like that case, and the outcome of all the federal courts in the United States. Holy shit. The plaintiff's counsel, and this court does not have to like defendant or what he stands for, but the court should give the defendant the benefit of the doubt and give defendant fairness. Well, actually, no, that's even wrong. That's wrong. This court should not give the defendant the benefit of the doubt. You know why? Do you know why they shouldn't give the defendant the benefit of the doubt? There's been a judgment. There's been a judgment by a competent court. That would be why. So no, it shouldn't give the default to the judgment, default to the defendant. It should give default to the judgment of the competent court. People in 1976 for 100 SE cases. Do you think a partial reason is to communicate to President-elect Trump and try to get some help rather than being serious attempt at getting something from the court? Like what? What even hypothetically could President Trump do even if he wanted to, short of paying the amount himself? So short of President Trump writing a check, I don't know what President Trump could even hypothetically do. I guess President Trump could give him a job, But would you give a whiny little asshole like this a job? If you're the president, would you give a guy who's this whiny a job? It's not like he's fighting strong. It's not like he's citing cases. It's not like he's, standing up as a lawyer, even if he were wrong, even if the cases he was citing were like off, it would be better. Like, at least then I'd be mocking him for citing law that's an opposite, not just whining and bitching. All right. There are a lot of bathrooms at the White House to clean. Fair. If this court looked only at the facts, there's no way for this court to ever rule that on the date the plaintiffs recorded and filed their judgment in Florida and New York, they were not entitled to homestead in Florida. That's the closest thing we have to a legal argument yet, is like they can't get at the condo. But like, we're not citing, you know what would be really helpful? If you cited some Florida law for that. You just keep referring to the homestead exception. You keep referring to the homestead exception. And like, I have a vague idea what it is. Like, I've heard of this concept, but I'm not a Florida lawyer, And even if I were a Florida lawyer, I might not necessarily be familiar with the homestead concept because, I might not be specialized in that field of law or, that might not be my background. So like, even if I were a Florida judge, you would want to like educate me a little bit. Part of your job as a lawyer is to educate me as the judge because I might not know. Because it might not be my field of law and you don't know who's reviewing this thing or who will review the thing in the future. So maybe you could cite some actual law dealing with the homestead exception. Maybe you could be like, here's the law, here's what it says, here's what the Florida Supreme Court has said, and be like, oh, okay. Thank you for telling me about what the Florida law is and what the Florida Supreme Court has said, and here's what the Florida statute says, and here's all the rest of it. Oh, that's really helpful information. Instead of just vaguely alluding to the homestead exception, teach me about the homestead exception. Please, for the love of God, teach me. The fact that the honorable judge was nominated to be a district judge in 2018, and the nomination was returned to the president under the provisions of the Senate Rule 31, paragraph 6 of the standing rules of the Senate, can subconsciously affect any human being. That is a horrible sentence, and you should never write that. Then when the honorable judge was nominated again, the honorable judge was confirmed by the Senate. So he was nominated once, and the Senate was like, no. And then he was nominated again. And the Senate was like, oh, okay. Who fucking cares? So he was nominated once and the Senate's like, nah. And then the president's like, but I'd really like him though. And the Senate's like, okay. I mean, okay. I mean, noted. However, when he was nominated again, the honorable judge was confirmed by the Senate. However, with no Democratic senators voting against the nomination, but 29 Republican senators voting against the nomination. That is the reason for the court to be very conscious of giving the defendant, who is only before the court because of politics and the 2020 election, a fair day in court. I am ruling against you so hard, it's going to make your head spin. And then I guess you're just going to whine about it some more. Tell it to the Court of Appeals, I guess. Tell it to the Court of Appeals. This court should be aware that based on everything submitted to this court, there is no possible way under the Florida Constitution, defendant is not deemed a Florida resident, domicile, and citizen with a person resident in Florida. Okay. One of the most important facts is that in July 2023, defendant listed his only New York residence for sale, and he did not seek to purchase or lease any other residence in New York. This was done well before any judgment issued in favor of plaintiff. So what you're telling me is he had assets in New York? Is that what you just told me? So they got judgment from DC, and then they filed the judgment in New York and filed the judgment in Florida because he owned property in New York. He listed it for sale. So you're saying he owned it? You're saying it's an asset that he owns? Oh, they're probably trying to seize it then. Because it's an asset he owns in New York. And they have a judgment that says that they get money. And so he has an asset, the property. They're probably trying to seize it because he owns it in New York, which is why we filed in New York. Yeah. Defendant listed his only New York presence for sale in July 2023 because he was preparing to move to Florida as his only permanent residence. And that's what defendant did. Okay. If this court reads between the lines of the plethora of plaintiff's counsel filings, the plaintiff seeks sanctions from this court to try to get this court to sanction defendant by taking away his homestead rights of the defendant. This is because the plaintiff counsel knows, unquestionably, the facts are such that on the merits, defendant has homesteading in Florida, and he has homesteading in Florida well before the August 5th, 2024 date when plaintiffs filed their judgment in the Southern District of New York and Southern District of Florida. Well, he may or may not have homesteading rights in Florida with respect to Florida property. But he has property in New York. I am quite positive. The laws of Florida do not grant a homesteading exception to property that's located in New York or any other state other than Florida. I'm pretty sure that the laws of Florida do not extend beyond the boundaries of Florida. That's where the Florida is. The Florida is located in Florida. Did you know that? The Florida is located in Florida. So I'm pretty sure the homesteading exceptions of Florida do not extend to the not Florida. This deep legal analysis has been brought to you by Uncivil Law. Okay. If this case were not a political one, the case would likely have very few filings on the docket, and this case would have taken the standard track, not to have an expedient trial with a case filed in August 24th and a trial of July 2025. By the way, not that I need to point this out, by the way, but when it comes to physical property, it is very well settled. The law that applies is the state to which the physical property is in. Duh. But in case I needed to point that out, like, it's pretty well settled that if you're trying to figure out what law applies and it's dealing with real property, the answer is the jurisdiction in which the property is located would be the law that applies. So Florida land is governed by Florida law. New York land is governed by New York law. Film at 11. Florida does not include New York. Florida is not the same as New York. Are these legal facts or are these geography facts at these points? I'm not even sure anymore. The defendant relies upon his prior counsel to respond to discovery demands in this case, but were not served. Well, if they weren't served, that would be a really good defense in district court in DC. If they weren't served, that'd be a really great defense. Did you raise that defense? Was it true? When defendant's present counsel came to this case, when defendant's prior counsel was granted permission to withdraw, in the approximately 3 weeks, there's been a substantial compliance with all discovery and court orders. Well, the DC court doesn't seem to think that. This court should know that no matter what is provided to plaintiff's counsel is and has been very unreasonable. Because this is about plaintiffs rushing to get to the finish line, getting all defendant's assets, pretty much, getting the defendant's homestead condominium in Florida, which is defendant's only permanent residence, and it's been so before a new administration takes office. Well, it sounds suspiciously like they're trying to get your home in New York. I mean, that sounds suspiciously like the reason they filed in New York is because they're trying to get your assets in New York, because that's where the property lives. It's very unfortunate. This guy failed property law 101. Did he fail property law 101 and not know that like New York law governs New York property? Did he miss a memo? It's very unfortunate that plaintiff counsel appears out to destroy defendant, who did a lot of great things for the United States and all citizens of the United States over a career of more than 50 years. Well, I mean, that much is true. I would tend to agree with you. He did a lot of great things, but he may have done some bad things, including some defamation, for which he might have some liability. The two are not mutually exclusive, incidentally. So there's that. Because of voluminous filings by plaintiff, the court likely looks at all the filings prepared by probably a dozen attorneys with endless resources, going against defendant with limited resources and limited attorney staff. Well, again, there are a lot of ways to deal with this problem. You could have asked the court for help. You could have asked the court for extensions. You could have asked the court for extensions. You could have asked for orders limiting discovery. There's a lot of ways to deal with this problem. But, yeah. It appears that plaintiff's counsel has made it very difficult for defendant's prior counsel, Kenneth Caruso and David Lefkowitz, with motions and filings continuously done until Kenneth Caruso and David Lapskowitz could not take it anymore. And they had to withdraw. And then you decided to take on this pinata? Well, that was your problem. I mean, if they said, mercy, mercy, we can't take it, and then you decide to adopt this pinata, it's like, okay. They still represent the defendant on the appeal before the United States Court of Appeal for the DC Circuit. Good luck. Defendant's counsel has experience in the voluminous filings by plaintiff's counsel, knows that it's likely at war with a dozen machine guns shooting at you. What the fuck are we doing now? What are we? This is not a legal filing. This is not a legal filing. I don't care that it has a legal stamp on the top of the page. I don't care that it has a docket entry. This is not a legal filing. What is this bullshit? Defendant's counsel has Defendant's counsel has experienced the voluminous filings by plaintiff counsel and knows, change highlight color, that it's like a war with a dozen machine guns shooting at you. And only one person to defend it. No. It's respectfully requested this courts take a step back and realize this is what happened. Defendant has substantially complied with court orders and discovery since defendant's present counsel began to take over the representation on November 26, 2024. Do you have anything new to say? Defendant was not the person responsible for the plaintiff not receiving discovery prior to November 26, 2024, and should not face any sanctions or penalty of any kind. At the end of the day, plaintiffs will not have been prejudiced in a matter whatsoever by the slower than optimal discovery production and compliance with the court's orders. And this court will hopefully see and hear all the facts. Can we please find some punctuation? Can we find an end of a sentence? Can we find the end of the sentence? That'd be really grateful. I'd be really, really happy if we could find the end of the sentence anytime soon. At the end of the day, plaintiffs will not have been prejudiced in any manner whatsoever by the slower than optimal discovery production and compliance with this court's orders. And this court will hopefully see and hear all the facts and decide that while plaintiffs can push very hard and with full force, it does not change the fact that under Florida law and the Florida Constitution, defendant was and is entitled to claim his condominium unit located in Florida as his homestead. Holy shit, learn to write. Learn to write. The Honorable Judge once said, oh my God, the quality of our system of justice is measured by the service it provides to the poorest and most despised members of the society. The poorest members of society. I'm pretty sure the court was not contemplating Rudy Giuliani when it wrote that. There are many individuals who are against President Trump and as such against Rudy Giuliani. And many members of society despise defendant Rudy Giuliani and President Trump. However, the quality of our system of justice is measured by the service it provides to the defendant like Rudy Giuliani. Who the plaintiffs and their counsel apparently likely despise. Well, I mean, as for the clients, they are suing you, so they're probably not super thrilled with you. As for the lawyer, I'm not sure whether or not they despise you or not. What I can say is that they're representing their client zealously and apparently quite effectively. So they seem to be good lawyers. It's defendant's recent understanding that the Honorable Judge, there's no way this is going to end well. There's no way this sentence is ending well. It is defendant's recent understanding that Honorable Judge is the son of late Arthur L. Lehman, who it has been discovered passed away at a time when Rudy Giuliani, there's no way this sentence ends well. At a time in which Rudy Giuliani was the prosecutor as the United States Attorney for the Southern District of New York, and the late Arthur L. Lehman, again, the father of the judge, was representing certain defendants in Drexel Lambert prosecution cases, Michael Meekin, Evie Boski, and Dennis Levin. Holy shit. Defendant hopes the defendant is afforded every right under the law by this court in light of the knowledge the defendant before this court is the person who was prosecuting the Honorable Judge's late father, Arthur L. Linson's clients, when or around the time the Honorable Judge's late father passed away. I'm sorry. What guide to winning friends and influencing people did we read that suggests, what would be a really good idea? Maybe if you cast aspersions on the judge's father, that would be really good. Maybe if you said, did you know that your father represented people that Rudy Giuliani was prosecuting? And you're questioning the judge by relationship to his father's. Who told you that casting aspersions on the judge's father was a way to win friends and influence people? Who gave you that memo? At this point, I'm expecting At this point, I'm expecting someone to walk out of an audience and slap this lawyer in the face and say, keep that man's name out of your damn mouth. Holy shit, man. Defendant should not be held in contempt. Well, maybe not, but defense's lawyer is doing a pretty good job of putting himself on the I really would like to be found in contempt train. He's doing a really good job on that, effort. Sanctions are not required to coerce defendant into compliance with any court order. I don't know, man. I don't know. It doesn't seem like it's going great. It is respectfully suggested that plaintiffs have not established by clear and convincing evidence defendant violated the district orders, and therefore, based upon the court's inherent authority, the sanctions should not be granted. Plaintiffs may not establish by clear and convincing evidence that defendant should be sanctioned, but I don't know, man. Defense lawyers doing a pretty solid job at it. I haven't read plaintiff's motion for sanctions, so I don't know whether or not plaintiffs have established by clear and convincing evidence that defendant should be sanctioned. But I don't know, man. Defense lawyers doing a pretty half decent job at it. Holy shit. As this court has seen, once prior counsel withdrew as counsel on November 26, 2024, present counsel for defendant ensued nearly full compliance with all court orders capable of being complied with. Plaintiff's counsel in the instant motion that defense should be held in contempt for violating the October 28th and November 22nd order. The fact is, defendant has complied with the October 28th, 2024 order and November 22nd, 2024 order. In the event the defendant did not fully comply with either of the orders, there is reasonable excuse for not fully complying, as defendants relied upon his prior counsels to comply with the two orders. Once present counsel for defendant took over representation from the prior counsel, there was full or substantial compliance with the orders. Because there has been full or substantial compliance with the orders by defendant, sanctions are not required to be imposed to ensure defendants into compliance with the orders. Additionally, plaintiff has not suffered any loss by non-compliance or delayed compliance. So there's no reason for the court to compensate plaintiffs for any momentary losses, as plaintiffs do not suffer any loss as a result of lack of compliance by defendant. At this point, as the court, I'm wondering, are corporal penalties available for a court? That's what I want to know. Can sanctions include corporal punishment? Because I'm really feeling like someone needs a switch to the back of their ass. Can I do that? Is that a thing? This case should be heard on the merits regarding the Homestead of defendants in Florida. Truthfully, plaintiffs should not even bring this case, because plaintiffs know that when they file their judgment in the United States District Court for the Southern District of Florida and the United States District Court for the Southern District of New York, defendant was at the time and well before a citizen of, domiciled in, and permanent resident of the state of Florida. This court should read between the lines of plaintiff's motion, but he had property in New York, though. He had property in New York. He had property. You said he listed it for sale. You said he listed it for sale. You never said the property sold, which means he owned it. That's why we're filing in New York. He has property in New York. He still owns the property. He might have listed it for sale. He didn't actually sell it. That means he owns it. That's why we filed in New York. We want the property in New York. Give us the property. That's why we're there. This court should read between the lines of plaintiff's motion and realize the only reason why plaintiffs are seeking severe sanctions are because the plaintiffs would like this court to say defendants should not be permitted to put on a defense at trial. Well, it seems like it's a little late for that, but okay. Because if this case proceeds to trial, Well, no, we already have that issue. They're not saying, well, I guess they are saying they shouldn't. Yeah, I mean, we already did the sanction. We already did the default. So they're not saying like we shouldn't proceed to trial. They're saying we're not proceeding to trial because the default was already ordered. So we're not doing it. So, yeah. Because if this case proceeds to trial, no. Did you not notice that the DC Court of Appeal said no? Or the DC Trial Court said no? Did you not notice that? So the only way for plaintiff to have victory in this case is for plaintiff to continue to have claimed deficiencies of discovery or violations of court orders and hope this court sanctions defendant. Well, that's looking pretty likely right about now. The defendant was not disregarding court's... Oh my God! It's a miracle. It's a miracle. It finally happened. It finally happened. It only took 20 pages, people. It only took 20 pages. But it finally happened. It's a miracle. It's a miracle. A citation. A citation. Oh my God, it only took 20 pages, but we found it. We found a citation. Holy shit. Holy shit, we found a citation. We know how to cite things. Oh my God. The court stated in a case from the Southern District of New York that civil contempt sanctions serve two purposes: to coerce a party into compliance or to compensate adverse party for any losses suffered at the lack of compliance. Another citation. A contempt order issued pursuant to court's inherent authority is warranted only where the moving party establishes by clear and convincing evidence the alleged contemptor violated the district court acts. Another citation. More specifically, a movement must establish that the order the contemptor failed to comply with be clear and unambiguous, the proof of noncompliance is clear and convincing, and the contemptor is not digitally attempted to comply in a reasonable manner. We found cases. We found 3 cases. 3 citations, man. 3 citations. All right. There was no willful noncompliance by defendant. As stated above, it's evidence that once defendant changed his counsel, a plethora of defendant responses in compliance with court orders was accomplished. It's respectfully submitted that the defendant in this case was not, that if the defendant in this case was not Rudy Giuliani, the plaintiff would not be seeking sanctions. Bullshit, they wouldn't. Of course they'd be seeking sanctions. That's what they do. They do it all the time. What do you mean they wouldn't be? If this wasn't Rudy Giuliani, they wouldn't be seeking sanctions? Of course they'd be seeking sanctions. They seek them all the time. They do it as a matter of course. They do it because they're having breakfast that day. What the hell are you talking about? The basis for the instant motion was what plaintiffs was stated in their memorandum of law. The plaintiffs had a memorandum of law, I bet they did, stating it's been more than a month since plaintiff's first set of the RFPs, and Mr. Giuliani has not taken a single step to respond to them in any way. Mr. Giuliani continues to evince no intent to respond to the first set of RFPs, even after the court's November 22nd order. Defendant's principal counsel ensured defendant produced documents and responded to discovery demands of plaintiffs. Plaintiff's counsel's declaration stated that, among other things, which of you people taught the child lawyer Latin? Which of you, who is responsible for this? Who is responsible for this? The child lawyer is going to try to use a Latin phrase now. Which of you guys, it's one of you in chat. One of you in chat is responsible for this. Who taught the child lawyer about Latin phrases? You can't trust the child lawyer with dangerous ammunition like that. That's something the grown-ups do. Is use, you can't no. Very bad chat. Someone in here taught the child lawyer about some Latin phrases, and he's going to try to use them now. This is on your head. You've trusted the kid with dynamite. Very, very bad. Plaintiff counsel's declaration stated that inter alia, holy shit, defendant's objection and response of not providing his email address and cellular telephone was a safety and security concern for his well-being, as there was previously threats received by defendants that were sanctionable. It is and was a very legitimate concern for this defendant. Oh my God. Different from many defendants, who was a United States attorney who prosecuted the mafia, I feel like we need to have quality time with this sentence, you and I. Is this even a sentence of English? Chris McIntosh for $5 Australian says, it was me by accident. I tried to read him Dune as a bedtime story. Okay. All right. So is this even a sentence of English is now my question. We'll put this in pink for not sure if this is English. It is and was a very legitimate concern for this defendant different from many defendants, he's not like the other girls, who was a United States attorney who prosecuted the mafia and was the former mayor of New York, who actually received death threats to not wanting to reveal his telephone number, which will likely be placed in the public domain by the plaintiffs. We're sorry. The uncivil that you're trying to reach is no longer connected. Please try your number again. What the fuck kind of sentence is that? Plaintiff suffered no harm by the defendant not providing his email address or cellular telephone number initially. Plaintiff's counsel declaration stated that, again, with the Latin, oh Lord, inter alia, defendant objected and responded to requests to identify in detail the efforts you undertook to preserve relevant evidence and collect and produce responsive materials in response to plaintiff's request for production, where the response was, I didn't throw out any document was sanctionable. The fact that there were documents produced by defendant to comply with court's orders. Defendant transferred the bulk of his assets to plaintiff. It's respectfully submitted there's nothing regarding discovery and the court's order that rise to the level of sanctions. This is, I have unironically seen pro ses better than this. I've unironically seen pro ses that are better than this. This is just sad. This is just sad. This is, don't write like this. Don't ever write like this. This is just, it's not even pitiful. It's just sad. You know, the only thing that comes to mind, is, I feel like someone needs to take this lawyer out for a walk, and then sit him down on a log overlooking a lake, as the sun sets. How beautiful this lake sunset scene is. ... This oh man, okay, sorry. What is really incredible is that the plaintiff are trying to obtain adverse inferences against defendant so as to get the ultimate relief that they seek in this case, which is for a declaration by the court, not the Florida court, that the Homestead defendant is not in accordance with the Florida Constitution and Florida case laws and statutes. Because plaintiff cannot prevail on the ultimate relief they seek, they believe that they can only get relief by seeking sanctions or adverse inferences. Plaintiff seeks the following adverse inferences. Plaintiff's memorandum on law, page 14. That Mr. Giuliani did not form an intention to live permanently at Palm Beach condo prior to August 5th, 2024. That Mr. Giuliani did not actually occupy the Palm Beach condo as a permanent resident prior to August 5th, 2024. Thank you very much, Chris McIntosh, for joining at the ultimate posse tier. That's very nice of you. For joining at the uncivil posse tier. That's very, very generous of you. Thank you very much. The undisputable fact is that Rudy Giuliani listed his New York cooperative apartment for sale in July 2023 because they formed an intent to live permanently prior to August 5th, 2024. And the defendant, Rudy Giuliani, did actually occupy the condo as a permanent resident prior to August 5, 2024. There's no way that plaintiff can prove or demonstrate that defendant Rudy Giuliani did not form an intention to live permanently at Palm Beach prior to August 5, 2024, or that Rudy Giuliani actually occupied as a permanent resident prior to August 5, 2024, because the fact that Rudy Giuliani began the process to relocate, which is not the same thing as relocating, by the way, in July 2023, when he listed his New York cooperative apartment for sale, and then actually occupied his Palm Beach condo as his permanent residence prior to August 5, 2024. That is why plaintiffs now want adverse inferences and a protective order precluding defendant from relying on, referencing, or otherwise using any documentary evidence in support of his claim that he established the prime Palm Beach condo as his homestead prior to August 5, 2024. Because plaintiffs are obviously concerned if this court meets justice out fairly and blindly, this court must find unquestionably defendant intended to use his Palm Beach condo in Florida as his permanent residence prior to August 5, 2024, and defendant actually did in fact permanently reside as Palm Beach condo prior to August 5, 2024. That would mean that while plaintiff did get all of plaintiff's defendants non-monetary assets, non-exempt assets, plaintiffs would not be able to seize the Palm Beach condo in Florida. Laurie Marie says, I teach middle and high school English. I'm literally at a loss for words. I know. This is just really, really bad writing. This is unbelievably bad writing. My kingdom for some paragraph breaks. Some paragraph breaks would be nice. How long is this paragraph? This paragraph is a page long. That's a very long paragraph. And we've had sentences that are entire paragraphs. And the flow kind of sucks. And it's very bitchy and whiny. And it's very, and there's all three cases cited in this entire thing. This isn't English. This is a travesty. And there's not even really argument. It's like, just the facts, man, would have been fine. Like, Rudy Giuliani moved to this house on this date. This is the date he moved there. And just the facts would be fine. I mean, come on. $50 from S.E. Key says, looking up, the Homestead defense is only valid for when the cause of action is in place, being the main domicile, not the judgment. Oh, I don't know the finer points of Florida homestead law. I can tell you it's pretty expansive. So I don't know the extent of it, but I do know that Florida's version of it is one of the more expansive in the United States. Florida is often said to be a debtor's paradise because Florida's homestead exemption is one of the widest in the nation. It's not necessarily the only one, but it is one of the widest. So if you want to protect your house, Florida is definitely probably the state for you. And it's unlimited. It's an unlimited homestead exemption, which is also nice. So no matter how expensive your property is, it's exempt, which is also nice. Again, Florida isn't necessarily unique in this way, but they definitely have one of the widest. So it would not surprise me. It would not surprise me if Rudy Giuliani's condo is unseizable. It would not surprise me, but these arguments are not making it very easy for me to reach that conclusion because these arguments suck. So, yeah. There's limitation on acres in Florida? Is there? I thought it was unlimited. Are there limitations on acres in Florida? I never claimed to be a Florida specialist. I just know that it's pretty wide and pretty. Is there an acreage limit in Florida? Anyways, I'm sure his condo's smaller than that, so that's not going to be the problem. What's really incredible, I'll tell you what's really incredible, this document I'm reading. This is incredible in multiple different senses of the word. It is literally incredible, as in not credible. So it is literally incredible. And it is also figuratively incredible because I can't believe that this came from a lawyer. And it's probably incredible in 2 or 3 other senses of the word too. This document is incredible in multiple different phrases. What's really incredible is that plaintiffs are trying to obtain adverse inferences against defendant so that they can get the ultimate relief they seek in this case. Yeah. Which is for a declaration by this court, not a Florida court, that the homestead of defendant is not in accordance with the Florida Constitution and Florida case law and statutes. Because plaintiff cannot prevail on the ultimate relief they seek, they believe they can only get this relief by sanctions or adverse inferences. Well, they're well on their way, I'll tell you what. Plaintiffs seek the following adverse inferences. Wait, did I already read this? I'm not reading it again. I think I already read this. Yeah, I'm not reading it again. I just lost track of where I am. Okay, argument 1, point 1. Standard of review. Oh, help me God. Federal courts possess certain inherent powers not conferred by rule or statute to manage their own affairs so as to achieve the orderly and expeditious disposition of cases. A court's inherent power to sanction derives from the fact that courts are vested by their very creation with power to impose silence, respect, and decorum in their presence and submission to lawful mandate. Civil contempt sanctions serve 2 purposes: to coerce a party into compliance or compensate an adverse party with any losses suffered as a result of the compliance. A contempt order issued pursuant to a court's inherent authority is warranted only where the moving party establishes by clear and convincing evidence the alleged contemptor violated the district court. More specifically, a movement must establish the order the contemptor failed was clear and unambiguous. The proof of noncompliance is clear and convincing, and the contemptor has not attempted to diligently comply in a reasonable manner. Before the court can hold a person in civil contempt, due process requires the person be given notice that he or she is defendant in a contempt hearing, and if he or she faces possible incarceration, that he or she be afforded the right to counsel. Due process requires that before being held in contempt, a party must have notice. Well, it sounds like you got notice, so I'm not sure what that problem is about. You know, you're not saying the court like did something without notice, right? The other party has filed the other. Do you not know how notice works? Like, you're not saying like the court just issued this willy-nilly without notice, right? The other side has asked for it. The court hasn't done anything yet. So why are you like saying we're entitled to notice and counsel? You have both those things. You have both notice and counsel. That's you, sir. Your counsel, the person writing this. Did you not know that? Were you confused in some way? That your counsel. He has you. Are you suggesting that you're not counsel? Are you suggesting that you're not qualified to be counsel? If that's your suggestion, I'm open for it, but I don't know if that's what you're going for. Are you suggesting that you're not in fact counsel, but you're rather two children standing on top of one another with an oversized raincoat? If that's what you're going for, then, you know, again, I'm open to that possibility. You know, this was not written by AI. AI cannot write this shit. This was not written by AI. You take that back, Kylie in chat. AI does not write this shit. This was not written by AI. You take that back. Whenever imposing sanctions pursuant to inherent power, a federal court may go no further than to redress the wrong party for losses sustained. It may not impose additional amounts for a sanctioned party's misbehavior. When £5 from Spartacus Articulus. I've heard more compelling legal arguments on Judge Judy. This is the kind of incoherent rambling I expect from Jerry Springer participants. I know. Judge Judy would demand more. Of course, Judge Judy was a real judge for 25 years. She really was a judge for 25 years. And then she's had a career. She's been a judge for 50 years. She was a family court judge for 25 years. If you ever want to like watch an old video, Google 60 Minutes interview with Judith Sheindlin. Judge Judy before she was Judge Judy. Judge Judy did an interview with 60 Minutes before she was Judge Judy. It's actually kind of an interesting interview. When she was still like a family court judge, because she was like one of the very few judges that opened her court to the cameras. And so 60 Minutes did an interview with her before she was Judge Judy, when she was still Judith Sheindlin, back in the old days. And it's pretty interesting because she has a very, very similar personality. She's been the same person for 50 years. It's pretty hilarious. Yeah. It's a good interview. You should watch it. It's old school. When interviewing, okay, we read all that shit. Okay, some other things. Point 2. Okay, so we just have a bunch of citations with no analysis. That's nice. That's definitely what courts like. They just like citations with no analysis. Jerry Springer has a law degree. I mean, he was mayor of Cincinnati. So yeah. Jerry. The court should be aware of Ovid versus Whiner, where Judge Dennis Hawley stated that plaintiff has submitted evidence that supports the assert. I'd rather have Jerry Springer as my lawyer than whoever this is. I'm sure Jerry Springer would do a better job. I'll happily. Is Jerry Springer available? Is he still taking clients? I'll take my chances, man. I'm sure he'd be good. This court should be aware of the case Ovid versus Whiner, where Judge Dennis Hurley stated that plaintiffs to submit evidence that supports the defendant is domiciled in the state of Florida. To wit, records showing defendant is a registered voter in the state of Florida, and defendant has been claiming the Florida Homestead available, which is only available to permanent residents. He's dead. That's unfortunate. I'll take Jerry Springer's ghost as my lawyer. Is Jerry Springer's ghost available and still taking clients? Anyone know a good seance? Anyone know a good psychic who can do a seance and get me Jerry Springer? I'll take my chances. Why don't I represent him? Why don't I represent Rudy Giuliani? I'm not fixing this nightmare fuel. I'm not fixing this bullshit. There's no way. I'm not fixing this bullshit. I'm smarter than that. I'm not taking on this turd pile and fixing it. There's not a chance in well, man. The ghost in Hamlet was pretty solid. The ghost in Hamlet was pretty solid. I mean, you know, so it's like ghosts are pretty good sometimes. In Ocmel versus somebody, this court was asked to award attorney's fees to proposed interveners. This court denied the motion for fees, but you do no analysis. This sucks. This citation is pointless and I hate you. I hate this citation and I hate you. This is a citation with no analysis or no analogy. I don't know why we're talking about it. In Ocmel USA versus Pickley International, this court was asked to award attorney's fees. This court said no. Well, what does that have to do with the price of tea in China? What does that have to do with the price of tea in China? That's some bullshit. In Hong versus Mommy Jamaican Market Corp, this court was asked, is that a real case? Hong versus Mommy Jamaican Market Corp? Okay, fine. This court was asked to impose sanctions against former counsel to the defendants pursuant to this court's inherent authority. The motions were based on the conduct of defense counsel, Mr. Lee, and moving to vacate this court's entry of default judgment and resisting the motion to reinstate the default judgment. In brief, as further described below, that conduct involves statements made to the court over multiple hearings, including under oath, in briefs and declarations that misrepresented when Mr. Lee began advising defendants, which was a central issue with respect to default judgment. I think I'm becoming dumber by reading this document. I think I am losing intelligence points. You know, I'm not alone in this, right? Like when you read something really great, right? When you read something that's like, you know, above you, it elevates you, right? You read something really great and it elevates you. It makes you smarter because you like have to really think, right? It pushes your intelligence up. It pushes your intelligence up. And, you know, sometimes for a moment, you're actually smarter than yourself. You know, you notch your intelligence up because it brings out the best in you. Because you're reading this really great material and you're really thinking and pondering on it. And you're like, wow, this is really great. And I have to really think about this. This is elevating me. This is elevating me. I can feel myself rising. I can almost touch the pantheon. I can almost touch the gods. I'm being elevated by this beautiful material. And then there's whatever this is. And, you know, this is the legal equivalent of moonshine from an unlicensed still by a guy wearing overalls. And it's possible I'm going blind. You know what I'm really afraid of? I'm really afraid of if I read enough of this, I'm going to start to like it. That's the really bad thing, right? I drink so much of the moonshine, it just permanently lowers my IQ. And all of a sudden I start thinking that this is the work of great literature. Does this stream need a content warning? Does this document need a content warning? Is it possible this document could result in permanent mental impairment? Is that possible? This court is imposing a sanctions for Lee for excess attorney's fees that plaintiff incurred the waste of judicial resources that directly caused by Mr. Lee's bad faith conduct, which unnecessarily and vexatiously prolonged litigation. Also, this is making me to not want to be a judge as much anymore. It's like, I thought about being a judge in the past. I thought, maybe being a judge could be cool. I'd write great decisions. Not necessarily that I myself am great, but the decisions themselves are great because they're speaking to great things. These are important things. But if I became a judge, I'd have to do this too. I don't know, man. I don't know. Is it worth it? In Asotella versus Linda Mehe, this court was asked to impose sanctions on a plaintiff pursuant to law for plaintiff's failure to appear at notice deposition. The court stated in its order that the mildest sanction is an order to reimburse the opposing party for expenses caused by the failure to cooperate. Monetary sanctions are the norm, not the exception, in which a party is required to engage in motion practice in order to obtain the discovery to which it's entitled. If monetary sanctions are not sufficient, more stringent orders may be issued, including adverse inference orders, preclusion orders prohibiting the introduction of evidence on particular points, and orders deeming disputed issues determined adversely to the position of the disobedient party. If the court were to impose any sanctions against defendant, they should only be monetary sanctions for plaintiff's expenses caused by failure to cooperate and not any adverse inference orders, preclusion orders, productions of inference, or orders deeming disputed issues. This may be the only thing. This is actually like an intelligent paragraph. Sort of. I mean, our standards are pretty low at this point. I'm desperately looking for pearls among the swine, but this paragraph, is actually making a valid legal point. Sort of. I mean, I could use with a paragraph break. I could use with it not being all one paragraph. I could use with some but it's trying. It's trying for something. In Soares versus Liquid Blue, this court stated the court finds monetary sanctions are appropriate at this stage. Counsel for defendant was present at an initial conference during which the parties discussed outstanding discovery requests, and the court issued the first of several orders with respect to discovery. Defendant has been given notice that non-compliance with court orders will result in sanctions. Defendant's non-compliance has been issued in this action for nearly 3 months, delaying the proceedings and causing plaintiff to incur additional costs pursuant to action. Because the rule requires the courts award attorney's fees and costs, unless the failure to comply was substantially justified or other circumstances made award of expenses unjust, plaintiff is entitled to attorney's fees and costs incurred in connection with efforts which the discovery was entitled. Give me a fucking paragraph break. This would be a great place for a new paragraph, man. Indent. Man, indent. Do you need to find the tab key? Please, just use a tab key. Damn. Should defendant continue to fail to comply with the court's discovery orders, further sanctions may be warranted. In Soares, this court ordered the defendant pay plaintiff's reasonable attorney's fees and costs to issue to obtain the discovery to which the plaintiff is entitled. In Soares, this court court acknowledged the defendant's noncompliance has been issuing this action for nearly 3 months, delaying the proceedings and causing plaintiff to incur additional proceedings caused and pursuant to action. In the instance case, there's been no delay as this court is holding the trial on January the 16th in 2025, and discovery in this case has been ordered to be very expedited. Holy shit. And there's been no delays to which plaintiff has incurred additional costs. In Rodriguez, plaintiff filed a motion for sanctions against defendant for noncompliance with this court's order of January 25th, 2024. All right. Look, we are just, look. All right, here's what I'm going to do. Instead of reading this paragraph, because this paragraph is a page long. Okay? So here's what we're going to do. I'm just going to ask ChatGPT to rewrite it, and we're going to read that instead. That's what I'm doing, and you can't stop me. And that's yeah. So okay. All right, ChatGPT, what can you help me with? Well, what you can help me with is, please rewrite this. I'll just say, please rewrite this. I'm not even going to give you instructions beyond that. Just please rewrite this. All right. Holy shit. All right, so what they meant to write was the following. In Soares versus Liquid Blue, the court determined that monetary sanctions were warranted due to defendants' repeated noncompliance with discovery orders. The court emphasized, block quote, the court finds that monetary sanctions are appropriate at this stage. Counsel for defendant was present at the initial conference, during which the parties discussed outstanding discovery requests, and the court issued the first of several orders with respect to discovery. Defendant has been given notice that noncompliance with the court orders would result in sanctions. Defendant's noncompliance has been an issue in action for nearly 3 months, delaying the proceedings and causing plaintiff to incur additional costs pursuant to action. Because the rule requires that the court award attorney's fees and costs unless the failure to comply was substantially justified or other circumstance make an award of expense unjust, neither of which is applicable here, plaintiff is entitled to attorney's fees and costs incurred in connection with efforts to obtain the discovery to which they're entitled. Should defendant continue to fail to comply with court order, further sanctions may be warranted. And block quote. Based on these findings, new paragraph. Based on these findings, the court in Soares ordered the defendant to pay the plaintiff's reasonable attorney's fees and costs incurred in obtaining the required discovery. The court highlighted the defendant's persistent noncompliance, which caused a delay of nearly 3 months, as well as additional costs incurred by the plaintiff to move forward. In contrast, new paragraph. In the present case, the circumstances differ significantly. This court is set to proceed to trial on January 16, 2025, and discovery has been conducted under an expedited schedule without any delays attributable to defendant. Unlike in Soares, there's been no undue delay or additional costs incurred by plaintiff as a result of defendant's actions. Therefore, under Rule 37, sanctions are unwarranted in this manner. ChatGPT knows how to write. ChatGPT is pretty good. That makes sense. That's coherence. Thanks, ChatGPT. In Rodriguez versus I'm not reading any of this. You can't make me. I'm not reading any of these things. You can't make me. Here's what he meant to say. In Rodriguez versus New Generation Hardware, the plaintiff moved for sanctions against defendant for failure to comply with this court's January 22nd, 2024 order, stating that on April the 12th of 2024, starting on April 12th, 2024, the court declined to increase the existing monetary sanction of $500 per weekday, but allowed the plaintiff to renew a request for defendant's arrest if non-compliance persisted beyond May 12th of 2024. The case involved violations of the Fair Labor Standards Act and New York labor law. After the plaintiff obtained a default judgment, the defendant failed to respond to an information subpoena. Consequently, the court imposed contempt sanctions of $500 per weekday and warned that continued defiance could lead to a court-ordered arrest. In Perez versus Edwards, the court imposed sanctions in the form of reasonable attorney's fees and costs, where the plaintiff demonstrated lack of diligence in prosecuting the case and repeatedly failed to meet the court deadlines. In the present matter, should the court grant plaintiff's motion, though it's respectfully submitted that such relief is unwarranted, the only appropriate sanction should be limited to reasonable attorney's fees and costs. However, it's further submitted that plaintiffs have not incurred any attorney's fees or costs attributable to any failure to comply with discovery or the court's orders and complaints. Thanks, ChatGPT, for rewriting that so I didn't have to read whatever he wrote. For the foregoing reasons, ChatGPT is the best. For the foregoing reasons, plaintiffs should be denied. The motion be denied in its entirety and for such other relief as it deems properly. Submitted, and he writes his name in lowercase for his signature, I guess. That's nice. Submitted, Joseph N. Camarita from Camarita and DeMeyer, attorneys for the defendant, Staten Island. Well, no.
Mr. Madison, what you just said is one of the most insanely idiotic things I have ever heard. At no point in your rambling, incoherent response were you even close to anything that could be considered a rational thought. Everyone in this room is now dumber for having listened to it. I award you no points, and may God have mercy on your soul.
Okay, a simple wrong would have done just fine, but
you remain one.
Well, my friends, I really don't know what more to say beyond that. That was unironically just one of the worst written legal filings I have read in quite some time. It was incoherent whining. It was incoherent whining. And at this point, I haven't read one word of what the plaintiffs wrote. And at this point, I'm like, whatever you want, plaintiffs. Whatever you want. What do you want? Just tell me what you want and it'll be yours. Just tell me what you want, and if it's within my power to grant it, it will be yours. So I don't think things are going to end well for Rudy Giuliani. I think is, at least with respect to the vast majority of his holdings. So things are not going to end well for him. And I really don't think it's going to make any difference who's the president, because, like, why would it make any difference? Unless Trump wants to offer Rudy Giuliani a job, and who would offer him a job at this point? He's just such a disgrace. Yeah, so I don't know. I don't know what he could possibly do at this point. Yeah. I mean, yeah, the only thing Trump could do is write the check. That's really the only thing that Trump could do, is write the check and bail out his friend. That's really the only thing Trump could do. I don't think Trump's in a mood to do that, though. So yeah. I assume that he'll probably keep his condo, but not much beyond that. So he could live in a van down by the river. That sounds pretty good, man. Van down by the river sounds pretty solid. Sounds pretty solid. Castrol, this was awesome. This was an awesome stream. Castrol Armand deserves credit. Thank you, Castrol, for bringing this story to our attention. We couldn't have done it without you. It may have been torturous, but watching me in pain is always exciting. And so if it helps with the channel, I'm here for it. So I do appreciate it. It was pretty dumb. And Tony, our mod, designed the thumbnail. So Tony designed the thumbnail, so he deserves credit for this pretty glorious thumbnail glory that he created. I don't know, man. I think I'm done for the day, and possibly some other times. I think I'm going to go out for lunch. Maybe I'll go out to Chewy's and get Mexican and a very big margarita. I think it's margarita lunchtime, I think is what it is. I think it's a two jumbo margarita kind of day. Possibly a flavored margarita of some kind, maybe raspberry or something would be good. But or I could go steak. That's actually interesting. I could go to the steakhouse and get steak for lunch. That's actually not a bad idea. I haven't been to a steakhouse in a hot minute. Maybe I should get a steak for lunch. That'd be good. There's a Longhorn Steakhouse not too far from me. I could go get a steak. Yeah, maybe I'll go get a steak and a big cocktail. Yeah, maybe I'll get a steak. And then I'll go to House of Pies and I'll buy a pie and eat that too. I've been Uncivil Law. Until next time, I hope all is well with my friends. Cheers.